Hello, my name's Sian Darlington and I'm a business crime and regulatory solicitor at Gunnar Cook in Manchester. I've been qualified as a solicitor for over 16 years, in which time I've acted for a variety of businesses and individuals who found themselves accused of criminal behaviour. I've acted for professionals such as lawyers and accountants, for large PLCs and small private companies and their directors, for partnerships, sole traders and employees. What I have learnt from my experience is that it is much easier than you might think for businesses to find themselves falling foul of the criminal law. I want to use my experiences to help businesses to understand what the law says, ways in which the law can be broken, and to provide some practical tips for businesses on how to prevent it from happening to them. So in the first of the series, I'm going to talk about money laundering. This is the process of making dirty money clean. So the proceeds of criminal conduct are placed into the financial system and then layered through a series of transactions and transfers before being withdrawn at the other end as legitimate funds. The law on money laundering is contained in the Proceeds of Crime Act, which makes it an offence to conceal or hide the proceeds of crime, to enter into an arrangement with another which assists them in using the proceeds of crime, or simply to use or possess the proceeds of crime themselves. For each offence, some knowledge or suspicion of money laundering is required, and suspicion is a very low threshold. It needs to be more than a mere sense of unease, but it doesn't need to be logical or reasonable or based on specific facts. So, how do businesses break the law? Well, if your business is simply involved in selling goods and services in return for payment, you're unlikely to be affected. But if your business has a transactional element, or if part of your business involves entering into arrangements with others which could facilitate them in a criminal purpose, or if the goods and services you supply could be used in the furtherance of a criminal purpose, then you could find yourselves falling foul of the law if you have knowledge or suspicion of money laundering. The consequences are severe, with a maximum prison sentence of 14 years. Courts also have the power to impose unlimited fines, and of course any investigation would be extremely disruptive, as would any freezing of the assets by the authorities. So, how can businesses protect themselves? I've got 3 top tips. 1. Assess your risk and record that you've done so. It may be that your business carries little or no risk, in which case, just diarise to think about it again in a year's time. If you do identify risks, then identify measures you can take to mitigate or prevent against those risks and record them. Some businesses will have additional obligations under the money laundering regulations. If that applies to your business, make sure that you're familiar with the regulations and that you regularly review your risk assessment policies and procedures and make sure they're working. 2. Make sure whoever deals with your finances is on the ball. Don't publicise your bank details, for example, on your website. If there is a request for the change in the destination of a payment, double check that. Look out for odd patterns and overpayments. Depending on the nature of your business, you may wish to impose a cash limit policy. 3. Talk to your staff. Make them aware of online scams such as phishing emails which seek to extract financial and personal information. Trust your instincts. If something seems too good to be true, it probably is. If something seems odd, investigate further. Encourage your staff to talk to you about anything that may arise in the course of their work. So, I hope that you found that helpful. If you do have any questions, please contact me on sian.darlington@gunnercook.com. I hope to see you again soon. In the meantime, take care and remember, don't let it be you.